What is up, guys? BJ Dell here, back with an all-new video about the business side of being an artist. This time, talking about the legal aspects and the nightmare that I've had dealing with lawyers in regards to my company, ProDraw. I'm gonna make this a Storytime video, so instead of you sitting there watching me talk, you can go ahead and listen and follow along as I draw this cute little cartoon turtle. Okay, so let's go ahead and jump into it. So if you aren't familiar with ProDraw, I officially launched the company last year after spending the previous year and a half designing a drawing grip for the Apple Pencil with plans for more products in the future. I know most artists' legal issues are going to fall under the copyright side of things, but with ProDraw being a brand and having physical products, I had to focus on the trademark and patent side instead, which meant hiring a patent and trademark lawyer. This is just unnecessary cost due to all the bad actors out there who are more than willing to steal and make knockoffs of anything and everything. Unfortunately, trying to protect myself from that outcome led me to being absolutely taken advantage of by the law firm that I hired. So here's the story and things to look out for if you find yourself in the same situation. Since we live in a fairly small town, we don't have local attorneys that handle trademarks or patents, so I had to look elsewhere. I talked with a few firms that I found online and received quotes from them, which I'll talk more about here in a little bit, but they were all out of state. In addition to finding the right billing approach, I also wanted to find something within driving distance to be able to meet in person. I eventually landed on Standley Law Group out of Dublin, Ohio, which is around about an hour and a half away. I initially met with attorney Jeff Norris of Standley Law Group on September 29th, 2022 to discuss retaining their firm. And with my background in art and print on demand, I understand the trademark process pretty well. And of course, I had completed my own research and my due diligence months prior to our meeting in determining a name and branding for the company. So ProDraw, it was already established before this first meeting. I had a DBA registered with the state of Ohio, the domain name was purchased, the website was built, the social media accounts were formed, the products and the packaging with the name on them were already manufactured too. This wasn't a case of meeting up with a lawyer to help me brainstorm names or validate an idea that I had thought up. At that initial meeting, I made Mr. Norris aware of this and I provided him with all of the USPTO related research that I had done, as well as a nearly completed trademark application form. And I say nearly completed just because I wanted to verify the date of first use that I should cite. Everything else was completely filled out, so I gave him all that along with the specimens needed to file and the classes and descriptions that you need to file too. One of the class descriptions and tests was not selectable from the pre-filled drop-down menus, so that needed addressed as well. I told Mr. Norris that I only needed assistance in determining that date of first use, adding that class description, and then filing the application, and that's all something we'll touch on later too. In addition to the trademark, I also, of course, needed a patent for the grip. So one thing to understand here, for products, there's basically two different types of patents. You have a utility patent and then a design patent. Utility patents are for how a product functions. They're more complicated. A lot of times they have moving parts. Design patents, on the other hand, they're pretty simple. They protect how a product looks, and that's pretty much it. It basically protects the shape. So the ProDraw grip was obviously a design patent. Even though I'm an artist, I'm not a technical draftsperson, but I still provided 5 drawings of the grip showing different angles and views like the USPTO requires, along with the physical grip itself. I told Mr. Norris that I wasn't sure if these were acceptable based on the patent office requirements, but I felt they would at least give a draftsperson a jump start in their process if they were, quote, not ready to submit. I also explained that I had talked with other law firms that worked on a flat rate approach and received quotes from a few different ones that totaled $4,350 for both the trademark and the patent. $1,500 for the trademark, plus an extra $350 filing fee for that secondary class, and then $2,500 for the patent. At the consultation, Mr. Norris explained that Standley LLP works on an hourly rate as opposed to a flat fee rate for filing TMs and patents due to each case being different. I said that was great for my situation. I really wanted to steer away from that flat fee approach since I had already done the majority of the work and supplied nearly everything needed to file. I didn't want to go with a flat fee structure that would result in me paying more for work that I'd already done and provided. He quoted me $2,250 for the retainer and said extra charges as a result of denials and refusals on the USPTO side would of course be billed hourly too, and there could be additional fees charged for the draftsperson based on whether they could use my drawings or not. I received Standley LLP's engagement letter later that day and promptly paid the retainer. As the engagement letter was worded, I believed everything was as discussed in the consultation. Specifically, the advance fees section read as follows. The advance we receive from you will be deposited into our general trust account. We will charge our fees and costs against the advance and credit them on our invoice. Any unused portion of the advance will be refunded at the conclusion of our representation. In the event our fees or costs exceed the advance deposited with us, we will bill you for the excess. So based on the wording of that section, I thought the services could at least have a chance of costing less than the required retainer. Once again, they're working on an hourly rate here, not a flat fee. In addition, using the phrase, in the event our fees or costs exceed the advance, implies that overages are a possible outcome, but not necessarily a guaranteed one, nor are they 100% expected. Neither of which could have been further from the truth because of what I was ultimately charged, so let's go ahead and get into that now. In total, I was billed $10,793.50 for the trademark and patent process. Both of these are currently sitting at the USPTO waiting to be assigned an examiner. This amount is not the result of any extra work due to denials or refusals or rejections. The retainer, that $2,250, that was gone in the first 18 days, with the first month's bill alone totaling $5,950. The total billed for trademark research and class research alone totaled 8.8 hours and resulted in a charge of $3,740. Despite the fact both were unnecessary, since I only requested assistance in determining that data first use, adding the class description in question, and then filing the application like I discussed in that initial consultation. The charge for the draftsperson drawings was only $400, while Mr. Norris billed $3,910 just for emails between him and myself and him and the draftsperson about the drawings. He never initiated a direct line of contact between just the draftsperson and myself so that we could discuss. He instead acted as a go-between in order to excessively bill for every single email he read and sent. One email in particular that Jeff Norris sent to the draftsperson after a few weeks of silence from the draftsperson simply read, so this part might get a little confusing. The attorney that I used, his name is Jeff, the owning partner of the firm, his name is Jeff, and I'll give you one guess as to the name of the draftsperson. That's right, his name is Jeff too. So anyways, back to this email. Hi, Jeff. I just wanted to check on how the drawings were coming for the grip. That right there, that's the entire email. That's it. And for that email, I was billed $85. Since all this has happened, I also did some digging on my own and found and talked to the draftsperson they used. And Mr. Norris never even provided the draftsperson with the physical product, only my initial drawings and pictures, which caused the draftsperson to struggle with features and perspective. Of my own accord and unprompted, I sent Mr. Norris a 3D CAD file of the product once I began to suspect that the draftsperson was never even sent the physical product. Once again, this was just a simple design patent, no moving parts, not a multi-part invention, just one single simple piece of silicone, people. If given the necessary information, there's no reason a skilled draftsman should not be able to complete a set of drawings without needing nearly $4,000 worth of email guidance from an attorney. Just ridiculous. And I just want to throw out there too, this draftsman is somebody that the law firm themselves retained or hired. This is not a draftsman that they have on staff. Also, this is not somebody that's actually local to their area either. They live hours away from the law office, so everything is all done remote. Even after the trademarks and patents were filed and no movement at the USPTO, Standley Law Group LLP still found reasons to bill. So in March and April, I saw a combined charge of $473.50 for reminder emails, and that also included a $130.50 charge to simply forward an email to me from Amazon. In total, I was billed $10,793.50, of which I paid $9,793.50. There's no outstanding balance, though, due to the fact that I was credited a whopping $1,000 in November 2022 after I called to complain about the charges, which was a drop in the bucket for the overzealous billing. I was also credited the final bills of that March and April that I talked about after I terminated representation with Standley in June of this year. That's right, I went ahead and fired them and got a new lawyer. Even with these credits, though, I still feel I was grossly overcharged based on that initial consultation and the work performed so much that I reached out to the owning partner, Jeff Standley, in June after I terminated the service. He stated that I was not overcharged, but still offered me an additional $1,000 if I would agree to an NDA, which would be me agreeing to, and I quote, that this is the complete and final end of it, that each party will forever drop any and all claims, actions, and or accusations, whether known or unknown, whether real or imagined, whether arising in the past, present, or future, that the party may have against the other party that arose from or that is related in any way to our past attorney-client relationship and or this agreement. Each party also agrees not to say anything negative about the other party. If you reject these terms, which is your choice, there will be no payment sent to you. These terms are non-negotiable. Whether you respond yes or no, there will be no more communications of any kind from us other than if you say yes, agreed, then we will send the check. But we will no longer respond to you via email, telephone, or otherwise. Despite this, I still email back with a counterproposal telling them I will not be accepting your offer of $1,000 / agreeing to an NDA. I will only accept the terms of ceasing any further actions or claims you previously set forth if your firm provides a refund in the amount of $4,970. This is the amount that I have paid, $9,320, minus the amount that I would have paid if I had used one of the numerous law firms that I previously contacted who worked on a flat rate fee of that $4,350. I believe this amount is more than fair and still results in me paying more to your firm than I anticipated since I specifically chose Standley LLP to save time and money over said flat fee approach. I think it goes without saying here, I did not receive nor did I expect a response due to his previous rude and unwarranted threat of terminating communication in that prior offer. Seriously, all of my communication with everyone I spoke with at their law firm was always professional and level-headed. To cut off communication like this, you would have thought that I was calling daily, cussing people out, showing up at the firm, and throwing papers around, which was not the case at all. So where do I go from here? Well, since they've cut off communication, I've had to go other routes. I filed a grievance with the Ohio Bar Association requesting fee dispute mediation arbitration, and I also registered a complaint with the Better Business Bureau. And obviously, leaving reviews of their firm where I can warn potential clients is something I feel obligated to do in this case as well. All right, so that's it for my legal woes story time. I appreciate you guys watching, and let me know down in the comments if you've ever had to deal with something like this before, and if you've got some further suggestions or know someone who does. Believe me, I am all ears. At this point, it's not even a money thing anymore. It's truly a matter of principle and fighting being taken advantage of because a law firm feels that they can just do it without any repercussions. Seriously, I've spent so much time dealing with all this already that even if I was refunded absolutely every single last penny that I paid, it still wouldn't make up for the time that I've spent on this. It just sucks when you have to do something like this to protect your business and then you still end up getting screwed over by the people that are supposed to be there to help you. All right, guys, that's it for today's video. Until next time, be careful who you trust and keep creating.